So good evening, good morning to everyone that's dialed in from all over the world. We're delighted to welcome you to this second annual mediation lecture in Hong Kong. My name is Simon Chapman from Herbert Smith Freehills in Hong Kong. We're very proud sponsors of the mediation lecture this year and delighted that this has become a real fixture of Hong Kong Legal Week. Obviously, the lecture this year is taking place in a virtual format rather than physically in person. But that does mean that we've been able to reach a very wide audience. We have almost 300 people signed up for the lecture this evening, which promises to be a really interesting discussion. And we're particularly pleased to have Mark Appel, who's joined us all the way from Malta this evening to deliver his lecture. And I will hand over in a minute to the Secretary for Justice, who will introduce Mark in a bit more detail. I just wanted to say how pleased we all were to see so much interest in mediation with all of the events that are taking place this week. Of course, there is the Set Piece Mediation Conference, which takes place on Friday. Events like this are really important for us as a firm to be associated with. It's particularly important for us to connect and to collaborate with colleagues and friends across the region and today, of course, across the globe to discuss trends in dispute resolution and in particular in mediation and best practices. And we're very much looking forward to hear Mark speak about some of the themes in Investor-State Mediation today. We've committed to sponsor this lecture over the next 5 years. And we, of course, hope to see many of you again next year, hopefully some of you in person rather than just over a screen. There will be an opportunity to ask questions of the speaker at the end of the lecture today, just as there would be in a physical format. You will see a Q&A button, hopefully, on your screen. Please do send through any questions that you have over the course of the lecture. They will only be visible to the three of us, and we will select the best questions and ask Mark to comment on those at the end of the lecture. But please do send through any questions that you have that you would like Mark to address in due course. So without further ado, I wanted to hand over to the Secretary for Justice, who will welcome Mark and introduce Mark more formally today. But thank you again to everyone that has joined in. And we look forward to a very interesting lecture.
Good evening, Simon, and good afternoon, Mark. I'm very pleased to be here to say a few words. The annual Hong Kong Mediation Lecture is actually, as Simon was saying, it's going to be one of the fixtures of the Hong Kong Legal Week. We started last year, and we are very, very pleased and honored for Herbert Smith Freehills to agree to sponsor it for 5 years. And we hope that this will continue to be a very good tradition that we in Hong Kong will be able to contribute to the development of mediation. It's very interesting also for Herbert Smith Freehills to be related in this way, because I understand that not only are they one of the largest leading global law firm, but they have in the law firm that provides alternative legal services in China. And I think that's an interesting aspect to note. And of course, the current Chief Executive Office, the CEO, Justin D'Agostino, has been in Hong Kong for a long time. And I'm very pleased that he's able to station here in Hong Kong whilst heading this law firm. So keeping the link in Hong Kong and putting Hong Kong also on the map, on the global map in that way. The evening tonight about the mediation lecture is also a very interesting subject, something also we in Hong Kong have been trying to promote, investment mediation. We've been running investment law and mediation training courses for the past 2 years, but for the COVID-19 pandemic, it would be the third time this year, but we're going to reschedule it. And this is a very important subject, and I think it is ticking up a lot of attraction. For example, next Monday, the UNCITRAL pre-intersession meeting, we will also be talking about investment mediation. So I'm sure we will be hearing a lot more on this subject. But most importantly, tonight, we are very pleased to have Mr. Mark Appel to talk to us on this very interesting topic, investor-state mediation at the tipping point. Mark is a long-term friend. We've known each other a long time. And most of you may know him through his senior executive positions at the American Arbitration Association and the International Center for Dispute Resolution. But some of you may not know, and I think it's very relevant to what we're hearing tonight, is that since 2016, Mark has served as the chair of the IMI Investor-State Mediation Task Force, working with state and investor representatives, expert academics, the Energy Charter Secretariat, ICSID, and UNCITRAL on investor-state dispute settlement reform and mediation in particular. Last year, Mark was able to join us in Hong Kong and spoke at the Department of Justice's Mediate First Pledge 2019, Mediate First, Unlocking Potential, and he spoke on, Can Mediators Be Deal Makers? And it was a very impressive session, and thank you very much, Mark, for sharing us your expertise last year, and of course, again, sharing us your insights and expertise here with us tonight. I'm sure all of you are very eager to listen to Mark and to learn from his experiences. And I will say no more and pass on, if I may, to Mark to share with us his expertise on this very interesting topic. Thank you.
Thank you, Madam Secretary, for that very, very kind introduction. I am only sorry not to be present with you today with friends and family in Hong Kong, but another day, perhaps. The subject of my presentation, which is investor-state mediation, is in fact a theme or a study in leadership, both personal and institutional. And I can think of no two better hosts for this particular topic than the Hong Kong Department of Justice and Herbert Smith, Hong Kong DOJ for their mediation first policy, and Herbert Smith for their Herbert Smith Freehills for their long-standing activity in the mediation field and their particular leadership on mediation advocacy. So this is a real pleasure. Some of you may be familiar with The Tipping Point, a book by Malcolm Gladwell. In that book, as well as in a follow-up book called Blink, Gladwell looks at how and when change occurs. What is that magic point in time, the tipping point, when that most powerful of forces, inertia, stops holding back change and necessary change? The topic of my speech seems to have arrived at that time and place. But what were the sticking points? What was required and what is required for change to occur? What accumulated events have led us to this place? So let's explore. You could be forgiven for asking why assisted voluntary settlements are a novel idea in investor-state relations. After all, mediation is well established globally as an efficient and effective conflict settlement tool, from divorce and child custody actions to major commercial disputes, mediators globally work with parties to create process, facilitate effective communication, and assist the creation of sustainable solutions. So why not investor-state mediation? Well, certainly it's not the absence of problems. Conflict is natural in any commercial relationship, but adding in significantly different goals. So the investor's profit motive on the one hand, and the state's interest in public interest and interest in public well-being on the other would seem to increase the opportunity for disputes significantly. In 2018, ICSID, the International Center for the Settlement of Investment Disputes, had 56 cases filed. I note parenthetically that ICSID had 21 cases filed in 2008, so that's something like a 200% increase over 10 years. Not bad in terms of growth. But mediation's growth and mediation success is in significant part due to the opportunity to craft negotiated solutions that aren't proscribed by either contract or law. So whether it be an extension of time or negotiated price or resource requirements. In 2016, an internationalist, a friend of mine, and I think a friend of the Secretary's as well, hearing that I involved myself in investor-state mediation, said to me, investor-state mediation won't work. States don't settle, but it seems they do. So between 1966 and 2020, ICSID reports that some 35% of the cases never went to conclusion, never went to decision. Now, other reasons beyond settlement exist, so exhaustion of funds, voluntary claim withdrawal, but I think it's fair to assume that a fair number of those cases were removed after a negotiated settlement was reached. And at its heart, mediation is a simple extension of the negotiation process. It's enhanced negotiation. Negotiation plus one, the mediator. So why not mediation in investor-state cases? Well, it turns out there was a whole host of reasons, but distilled, many of them come down to trust. Investors and states won't use a process they don't trust. The good news is that over the last 8 years, much has been done to provide needed education and address legitimate concerns with the investor-state mediation process. So what follows now in my remarks is a bit of an event chronology with object lessons in leadership, in effective communication, and in innovation. In 2012, the International Bar Association published a set of investor-state mediation rules. The drafting committee was chaired by two veteran investor-state practitioners, Anna Jubin-Brett and Bart Legum. At the time, Anna was in private practice. Now she is the chief legal officer of UNCITRAL. Before moving to private practice, Bart, of course, had worked for the U.S. State Department, so plenty of experience there. The drafting committee for the IBA rules read like a who's who of internationalists' leadership counts, as do rules. Rules, like legislation, make practice legitimate. They normalize practice. They also set the standard for what process consumers can expect. I'm recalling now one of my own law school professors who too many years ago held up a set of procedures, a set of, in this case, commercial arbitration procedures, and said they reflect the common law for that process. The IBA investor-state rules addressed both novel and best practice approaches to mediation for investor-state cases. By way of example, they addressed the possibility that two mediators, or co-mediators, might be utilized. Why two? Why two? Well, think of an investment project in trouble over community, environmental, or labor and employment issues. Might it not be helpful to have an experienced, treaty-savvy mediator working in concert with a trusted, locally based mediator more in tune with community concerns? The IBA rules also adopted best practice in mediation, speaking to an organizational meeting, a mediation management meeting, and recognizing the value of addressing critical issues up front, including language or languages, pending arbitral or judicial proceedings, and their impact on the process, the possibility of adding additional parties to the mediation whose participation might be critical to its success, privacy and confidentiality issues, and any special requirements for ratification of the ultimate mediated, negotiated settlement. I'll speak to two other sets of rules later, but in truth, in 2012, the IBA leadership raised the bar. The intersection of public international law and commercial law has always made for an interesting debate regarding what skill set and knowledge base are best suited to the resolution of IS, or investor-state claims. Add political considerations, the possibilities of multiple forums, so arbitration, mediation, court actions, and widely disparate cultural dynamics to that mix, and you might start to appreciate the challenge of identifying the right person to assist the negotiation of investor-state disputes. In one of the first reported investor-state mediation cases, the parties used the services of one Robert Strauss. Robert was a legendary attorney, an advisor to 3 U.S. presidents and multiple corporate CEOs. Talk about setting the bar high. In 2014, the IMI, the International Mediation Institute, recognizing an opportunity to support mediation in investor-state relations, created the IMI Investor-State Mediation Task Force. The first co-chairs of the task force were Anna Jubin-Brett and Bart Legum. Importantly, the task force took on the subject of qualifying investor-state mediators, bringing in many of the same international experts, academics, arbitrators, mediators, and institutional representatives who've been actively engaged in bringing investor-state mediation to the fore. In 2016, I inherited Anna and Bart's good efforts as chair, and in September of 2016, IMI published its competency criteria for investor-state mediators. It's available in detail on the IMI website, but it lays out 6 areas for examination: an understanding of investor-state issues, experience in mediation and other dispute resolution processes, so the need to understand multiple fora, experience with different types of negotiation, mediation, and conciliation, understanding of arbitration, and not surprisingly in this context, intercultural competency. And then lastly, a broad omnibus catch-all other competencies. So subject matter expertise is useful, process management skills, obviously useful, technological know-how, wasn't that forward thinking considering our reliance on ODR, on online dispute resolution now. By way of comment, we mediators understand that you take parties as you find them. And so they come from different cultures, different legal and political business systems. They hear and speak differently, and so different styles of mediation really must be contemplated. I'm remembering again a comment from a colleague many, many years ago who asked if she was facilitative or evaluative in style. She replied, yes. So she said, I facilitate in the morning and I evaluate in the afternoon. The selection of the mediator could be a topic on its own for one of these talks, but it's important because it gives process consumers a baseline in terms of expertise and experience to consider. Perhaps needless to say, it's a tall order to find someone who ticks all of the boxes I've already given you. So what do you do? Well, I've mentioned earlier the involvement of leading investor-state ADR institutions, so the Energy Charter, Secretariat, ICSID, and UNCITRAL. Those same institutions, supported by IMI and working in close concert with the Center for Effective Dispute Resolution, DeCEDR, developed and delivered, this is pre-pandemic, a global series of investor-state mediator training programs. Unsurprisingly, those programs were built around the IMI criteria. They included intensive sessions on ISDS environment, ISDS law, and ISDS practice, followed by a mediation skills training built to suit the investor-state environment. By way of example, one of the role plays in the training program involved a civil society organization participating in the negotiation process. Perhaps not surprisingly, attendees came from different worlds. So they were international, public international lawyers, they were investor-state arbitrators, they were commercial mediators. I had the privilege of attending one of those programs as faculty, and I can tell you they were extraordinary. It was extraordinary. So, courtesy, thought leaders, broad parameters of investor-state procedure is in place. The question of mediator competency and quality is being addressed. But nagging doubts still existed. A 2016 survey of experienced ISDS practitioners by the Center for International Law, National University of Singapore, pointed up some concerns. It was the strong consensus of those surveyed that states would find the mediation option more problematic than investors. Number one among perceived obstacles to acceptance was the perception that states preferred to defer their decision to a third party. I'm going to give it to an arbitrator. I don't want to make this decision. Why, you might ask? Dig a bit deeper as they did, and you'll find out why. Obstacle number 3 was the first of objections entitled fear. In this case, fear of public criticism. Also, fear number 7, fear of future prosecution for corruption. Or fear number 16, fear of setting a bad precedent. As any student of history or business management will tell you, Fear is a great motivator, or as in this case, a demotivator. Now, having already staked out a leadership role, ICSID institutions once more stepped into the breach, starting with the Energy Charter Conference, Energy Charter Secretariat. Alejandro Carballo led its staff in 2016, understanding full well that neither investors nor states would participate in a process they didn't understand, worked with IMI, with the task force, to draft an investor-state guide to the mediation process. The guide is comprehensive in nature, addressing both practical and procedural considerations. So by way of example, considering when is the right time to mediate, or how to prepare for mediation, or how to provide for transparency, important in public matters, even while allowing for necessary confidentiality in the negotiation process. But the ECT didn't stop there. Instead, they carried out a long series of running separate workshops and seminars with government representatives, investors, and investor-state dispute settlement experts. That dialogue allowed ECT to explore many of the concerns addressed in the Singapore survey, minimizing some and illuminating causes and possible solutions for others. Here are a couple of examples. It's always been assumed that the need for transparency would limit states' ability to negotiate complex contract and treaty-based claims. But state representatives reported that they had found ways to maintain transparency. So, reporting on the existence of the dispute, transparent, reporting on the outcome of the settlement, reporting that the parties were engaged in negotiation, all transparency, all the while preserving the confidentiality of the negotiation sessions themselves. A less anticipated problem proved much tougher. It turns out that many states lacked, and I suspect still lack, necessary structural and policy support for mediated negotiation. Too often, even if the state wanted to mediate, there was either a scattered, limited, or no process in place or a budget to turn to. So the state literally had no way to pay a mediator. You can hire one, but not pay them, unfortunately. On receiving this feedback from the Secretariat, the Energy Charter Conference charged the Secretariat with drafting a protocol or protocols that could voluntarily be utilized by states, either by way of developing a domestic investor-state dispute resolution framework or serving as guidance concerning the practical and legal issues that should be considered by states in developing a conflict management plan for investment disputes. ECT staff started working on these issues with a select subcommittee of the IMI, Investor-State Mediation Task Force. ECT also continued its discussions with state representatives and investor-state institutions. The resulting Energy Charter model instrument on management of investment disputes. I'll say it again. Energy Charter model instrument on management of investment disputes delivers the requested comprehensive approach to investor-state conflict management. So the model instrument makes conflict management good policy, creates an administrative and budgetary framework, addresses the need for early and effective between agencies, communication and cooperation requires it. Balances competing needs for transparency and confidentiality. Importantly, the model instrument produced a really innovative idea, a way to address legitimate concerns about political backlash and potential charges of corruption, creating a multi-agency commission, so finance, state, multiple agencies, to manage treaty-based disputes. Simply stated, shared decision-making, shared success. Earlier, when talking about the IBA Investor-State Mediation rules, I spoke to the power of procedural rules in terms of legitimizing and normalizing process. It should come as no surprise then that as mediation has become better known, ICSID, World Bank, and UNCITRAL separately took up the challenge of drafting new mediation rules. For reasons I'll explain briefly, those rules are different. I'll start with ICSID. ICSID staff, and Frau Konitschka in particular, have been part of virtually every major new initiative in the development of investor-state mediation. From the start, ICSID faced two issues. Many, if not most of you, will know that ICSID has featured for years a conciliation process as opposed to mediation. The terms conciliation and mediation are frequently confused, and for many mean one and the same. But ICSID's process was well defined, if less frequently used, and clearly wouldn't meet current expectations of the mediation process. And speaking of process, whatever mediation process ICSID published and will publish will need to dovetail or fit, with existing ICSID administrative process. So like the Energy Charter Secretariat, ICSID engaged in lengthy conversation with ISDS users, arbitrators, mediators, experts, and academicians. What has resulted to date, and I say to date, the hope is that the ICSID mediation rules will be adopted in 2021, is really a bespoke investor-state mediation process. The rules are detailed in terms of filing and registration requirements, but it strikes me that's natural given their place in the larger ICSID dispute settlement process. Happily, they also reference several ISDS specific opportunities and needs. By way of example, the draft ICSID rules specifically address the possibility of one or two mediators, co-mediation. They also recognize that the more complex nature of investor-state disputes will benefit substantially from fulsome early discussion of procedural matters. The first session, as it's captured by the rules, suggests discussion of representation, communication, confidentiality, and ratification issues, among others. Important. Early discussion avoids misunderstandings later. So you can imagine one of your commercial colleagues now asking you, why is it taking so long for them to respond? And you happily will have an answer. Early discussion also, an agreement on procedural matters, creates what we in the mediation or the negotiation field like to call habits of agreement. Gets things rolling. It's a good thing. sets a good table for further discussion. There are subjects that aren't mentioned in the rules and might be considered. So, for example, something I would consider, and mediators will certainly think about addressing in that early management conference, is addressing the issue of public pronouncements or public communications. For those of you active in the public fora, how many times have you heard better to avoid negotiating through the press? Now, the draft UNCITRAL rules, so I'll change it now. We're now talking UNCITRAL as opposed to ICSID, have taken a different course, but again for good reason. The UNCITRAL rules historically have been the global standard for a whole host of commercial disputes. Any UNCITRAL rules would necessarily be less focused on any particular commercial use, let alone something as specific or esoteric as investor-state mediation. So that's resulted in simplified, or perhaps you could characterize them as only the essential mediation rules. By way of example, the UNCITRAL rules speak to when mediation begins and ends, appointment of the mediator or mediators, conduct of the mediation, and communication, including provisions for an early meeting, confidentiality. By the way, confidentiality all. So even under the UNCITRAL rules, even the settlement agreement itself is confidential, absent the agreement of the parties otherwise, or is required by law, or if required for enforcement. And the non-admissibility of mediation communications and other proceedings. The settlement agreement is addressed, and particularly in the context of an enforcement regime. So now UNCITRAL is thinking about the Singapore Convention. And mediator immunity. So immunity from service and process. We don't want mediators testifying in post-mediation proceedings after the fact, and limitation of liability for mediators. I note, and you can see if you go on the UNCITRAL sort of legislative pages and commission notes, that there have been some very useful comments from various states on the draft. Notable among them are calls from both China and Italy to make express the option of online dispute resolution as an option. How appropriate in light of today's address. And the common now ODR mediation. What should prove of immense value to parties and practitioners alike is the draft UNCITRAL notes on mediation, also forthcoming. Many of you will be familiar with the UNCITRAL notes organizing the arbitration proceedings, originally published in 1996, I think, and updated in 2016. The mediation notes now, UNCITRAL mediation notes, provide both rationale for the procedures themselves and also practical advice concerning organization, conduct of the proceedings, including ODR, and enforcement issues, speaking to the convention, which of course brings me to perhaps the single most important contributor to increased confidence in international mediation, which is the Singapore Convention itself. Many of our colleagues in the mediation community could be forgiven for understanding the need for an enforcement mechanism for mediation. After all, mediated settlements are arrived at voluntarily by the parties. I recall a study favorably comparing the staying power of mediated settlements to judicial orders in the United States some 40 years ago. So it's a long time history. Still, we're trying to change perceptions. and some issues. So it is a fact that in many jurisdictions, a mediated settlement requiring future performance is tantamount to a contract, with the usual defenses to enforce. So lack of agreement on essential terms, lack of authority. And that has made users uncertain. Certainty does not bring success, and certainty doesn't bring use. At the 2016-2017 International Mediation Institute Global Pound Conference, one of the top-ranked, in fact, maybe it was the top-ranked need for process change for users was legislation for enforcement and recognition of mediated agreements. Enter the United Nations Convention on International Settlement Agreements Resulting from Mediation, the Singapore Convention. The Singapore Convention provides a simple, straightforward, global mediation settlements enforcement regime. A couple of quick notes. The convention is designed to act as a shield as well as a sword. So it's for enforcement, but it's also for protection. So protection against future legal actions. The protection is, quote unquote, already settled. In deference to states, yes, so comity, the convention relies on existing state enforcement regimes. Now there are issues. Yeah? So the convention has grounds for setting aside mediated agreements, including public policy. So clearly, attention will need to be paid post-ratification to court decisions in particular jurisdictions. Finally, I've noted that 3 ratifying states, Belarus, Iran, and Saudi Arabia, have exempted the state from coverage under the convention. With respect, I think that's a lost leadership, lost revenue opportunity. States, and particularly states wishing to encourage foreign direct investment, will do well to include state agreements within the protections afforded by the convention. This is especially true given developments in the field. The state is in a position to establish an enforcement regime itself. And readily available tools like the Energy Charter, model instrument for management of investor-state conflict are available to states to create that regime. So effective state notice, thorough preparation by the state, vetting, and response. I'll mention one other thing, about a minute, I think. The convention's second opt-out, or option, is reserving a finality in terms of the settlement agreement until the time of mediation. I could see an argument being made for the state that for settlements involving the state, that settlement should be agreed to at the time of mediation. What it would do, and I'm now thinking with a state hat on, it would give me leverage at the negotiation table. So I am now in the position of saying, not only are we going to agree, but we're going to agree, and the agreement is going to be enforceable under the Singapore Convention. Now, implementation and dialogue and process goes on notably at UNCITRAL Working Group 3, where Investor-State Forum is going on, and I'm told that investment mediation is a important topic of discussion. So what about results? As the old proverb says, the proof of the pudding is in the eating. In a recently reported IS mediation, I should say successful mediation, the profile of the mediator who assisted the reporting state investor looks a whole lot, if you look at her profile, looks very much like the IMI investor-state mediation criteria. Also, today, in anticipation of this seminar, I noted that on the IMI website, the page featuring the Energy Charter Model Instrument has been downloaded over 16,000 times. So someone's interested. For those of us familiar with the history of the New York Convention, it might come as something of a surprise or perhaps a delight that to date some 55 states have adopted the convention. Now you might say, what about COVID? One of our discussions every day, it seems. Well, if anything, it seems to me COVID has accelerated the need for negotiated solutions. Investors are plagued with supply chain disruptions, with employee availability, employee health. States, on the other hand, are reallocating budgets to address dire public health and economic circumstances brought on by the pandemic. So, I'll end as I started. Is investor-state mediation at the tipping point? I think so, but time will tell. Kind thanks for your attention, and I'd welcome a few questions.
Mark, thank you so much for that really fascinating overview of the issues in relation to investor-state mediation. You touched on a large number of topics that I think will be of interest to those who have joined us remotely. And I just wanted to remind everyone that you're free to submit questions in the Q&A button, which should appear somewhere towards the bottom of your screen if you do have questions for Mark. We did have a couple of questions already that have come through over the course of the lecture. The first question, Mark, was a sort of practical question in relation to timing. And you talked about the sort of effectiveness of investor-state mediation more generally. In your view, do you think it's more likely that there would be a better uptake for investors using the mediation process as a remedy of first resort, if you like, so before any formal proceedings are commenced? Or is it more likely that the draft rules that you've talked us through will be invoked more frequently while some form of formal proceeding is already underway?
Yeah, thanks, Simon. Great question. I have to say I'm reminded on this day of the, I guess the day after the U.S. elections, of something I used to hear in the U.S. about Chicago. They would say, vote early and often. And I think I think mediation should really be contemplated early and often. Mediation is an excellent conflict management tool, and you need not have even a claim in place to take advantage of the a mediation process. I think the best users of the process, again, now speaking to both states and investors, why wait for it to get to a point where someone needs to file for investor-state arbitration? Why not engage a mediator when the problem surfaces, while there are still multiple sort of creative and effective problem-solving solutions available? So I really appreciate that question. Now I have to say, is it still effective at the time of and during an investor-state arbitration? And again, I would say yes, perhaps in parallel. Frankly, I think mediation, and I've seen it work in a post-award context, because it's lovely to win, but it's important to collect. And mediation can be a great way of taking a decision of some kind and then negotiating an outcome that is agreeable to the parties. So I guess, Simon, early and often is how I would answer that question.
That's a good answer. One question that's just come in. You've talked to us over the course of this lecture about the development, the history of mediation in the context of ISDS matters. One question we've had from somebody who's dialed in is to ask you to look into your crystal ball and tell us, what do you think about the development of investment mediation, perhaps over the next 10 years, so looking into the future?
Yeah. Okay, that's a great question. And of course, it is, as we all know, dangerous, at the very least, to try to prognosticate. But if we are at the tipping point, think about the universe of cases. If 35% of the cases that are being, even only 35% of the cases at ICSID are being resolved short of a hearing, that's a terrific number of mediations to start with. And assuming, and I think we have to assume that globalization will continue, no matter our politics of the moment globally, wherever we may be located. We really have come to rely on each other. I think mediation will have a far rosier future in terms of use as a conflict management and dispute settlement tool for investor-state mediations. So I think it's if the person who submitted that question, I would say, get that training now, because it's coming.
One topic that you touched upon was some of the training that's being given or produced to prepare people to be good mediators in the context of ISDS cases. Do you think that people who are good arbitrators can also be good mediators?
It's a very good question. It's the same question I used to be asked when I was asked whether judges would make good mediators. And of course, you give them the famous lawyer's answer, which is, it depends. I think some arbitrators actually have very good interpersonal communication skills, can work with parties. Some of them exhibit that, I think, in the best of them, in a preliminary hearing context. Look at the ones who really draw out agreements, draw out stipulations. I think arbitrators who have that kind of approach are going to be better suited to serve as mediators. Having said that, mediation and arbitration are very different skill sets. And just as there are some mediators who really would not do so well as arbitrators, there are some arbitrators who would not do so well as mediators.
And then perhaps one final question, just as we're coming up to the hour. You talked about the confidentiality of mediation proceedings, and I think you mentioned that for some of the draft rules, confidentiality is baked in by default, not just for the mediation itself, but also any settlement agreement that is reached as a result of the discussions. Do you think that there's a slight tension between the obvious need for privacy and confidentiality in the mediation context and the push for greater transparency with regard to the settlement of investor-state disputes more generally, sort of this push for more information to be published in the public domain? Is there an inherent tension, do you think, there?
Absolutely, and speaking from Europe, where we saw a really cascading sort of a public, very public and very heated suggestions that investor-state arbitration was somehow a smoky room sort of agreement, smoke-filled room sort of environment where people came to decisions that affected the public. So clearly that concern exists whenever you involve public entities. Having said that, it was very interesting discussions at the Energy Charter organization to hear governments say that by making particular aspects of the process transparent. So we support it. By the way, it's easier if you have a policy supporting mediation. Yeah. So now you say, of course we're mediating. We mediate whenever we have a problem. And then after that, we're in a negotiation with X. But then, you don't bring the camera into the negotiation room. Maybe you agree with the mediator as the mediator perhaps saying what's going on. Mediator will say something like, we're engaged in frank discussions. Okay? And then, ideally, the parties then make public the ultimate settlement agreement. So there is a way. The tension absolutely exists, but there is a way to address it. Parenthetically, I know that the ICSID rules actually have gone back and forth on the issue of what's confidential. And they now require confidentiality for every aspect of the process. So that shows you just how sensitive that issue is.
Well, Mark, we're right on the hour. It's exactly 8 o'clock in the evening in Hong Kong, so perfect timing. Thank you again. It was a terrific lecture, really interesting review of what is a fascinating topic. And as you said a few moments ago, a topic that's likely to see sort of significant development over the next decade. So thank you again for agreeing to be our speaker at the second annual Hong Kong Mediation Lecture. And thank you to everyone that's dialed in and that has asked questions. It's great to see so many people from so many different parts of the world and lots of different organizations represented this evening. So thank you all, and wish you all a very good evening.
Thanks, Simon.